points in Leonin cases 2018. JERSON TORTAL November 12, 2018. Rule 47, Section 3 then provides that an action for annulment of judgment, if based on extrinsic fraud, should be filed within 4 years from discovery of the fraud. Or if based on lack of jurisdiction, then before the action is barred by laches or estoppel. Under the doctrine of res judicata, a matter that has been adjudicated by a court of competent jurisdiction must be deemed to have been finally and conclusively settled if it arises in any subsequent litigation between the same parties and for the same cause. Certainly, the remedy available to defendant TORTAL is not in this proceeding, but through a petition for annulment of judgment with the Court of Appeals under Rule 47 of the Rules of Court. SINDOPHIL November 7, 2018. The presumption that a holder of a torrens title is an innocent purchaser for value is disputable and may be overcome by contrary evidence. Once a prima facie case disputing this presumption is established, the adverse party cannot simply rely on the presumption of good faith and must put forward evidence that the property was acquired without notice of any defect in its title. Procedural rules are tools designed to facilitate the adjudication of cases. Courts and litigants alike are thus enjoined to abide strictly by the rules. And while the court, in some instances, allows a relaxation in the application of the rules, this, we stress, was never intended to forge a bastion averring litigants to violate the rules with impunity. The liberality in the interpretation and application of the rules applies only in proper cases and under justifiable causes and circumstances. While it is true that litigation is not a game of technicalities, it is equally true that every case must be prosecuted in accordance with the prescribed procedure to ensure an orderly and speedy administration of justice. With SINDOPHIL failing to prove that it was a buyer in good faith, it cannot recover damages to be paid out of the assurance fund under Section 95 of the Property Registration Decree. In Maribana v. Bernardo, this court held that it is a condition sine qua non that the person who brings an action for damages against the assurance fund be the registered owner, and, as to holders of transfer certificates of title, that they be innocent purchasers in good faith and for value. Property Registration Decree, Sec. 95 provides, Section 95, action for compensation from funds. A person who, without negligence on his part, sustains loss or damage, or is deprived of land or any estate or interest therein in consequence of the bringing of the land under the operation of the torrent system or arising after original registration of land, through fraud or in consequence of any error, omission, mistake or misdescription in any certificate of title or in any entry or memorandum in the registration book, and who by the provisions of this decree is barred or otherwise precluded under the provision of any law from bringing an action for the recovery of such land or the estate or interest therein, may bring an action in any court of competent jurisdiction for the recovery of damages to be paid out of the assurance fund. CITIGROUP, June 13, 2018. Trademark. Upon consideration, it notes that it may have been more aligned with the purpose of trademark as protection for respondent to have chosen the trademark CITYSTATE cash instead of City Cash, to create a stronger association between its trade name and the service provided. Nonetheless, there is no law requiring that trademarks match the offeror's trade name precisely to be registrable. The only relevant issue is the likelihood of confusion. This court also recognizes that there could be other situations involving a combination of the word city and another word that could result in confusion among customers. However, it is not convinced that this is one of those situations. Thus, having examined the particularities of this case, this court affirms the Court of Appeals finding that Director General Cristobal of the Intellectual Property Office did not commit any grave abuse of discretion in allowing the registration of Respondent's trademark. Francisco I. Chavez, June 27, 2018. Representative Act No. 265, Sec. 34 provides, Section 34, proceedings upon violation of laws and regulations. Whenever any person or entity willfully violates this act or any order, instruction, rule or regulation legally issued by the Monetary Board, the person or persons responsible for such violation shall be punished by a fine of not more than 20,000 pesos and by imprisonment of not more than 5 years. Central Bank Circ. No. 960, Sec. 4 reads, Section 4, Foreign Exchange Retention Abroad. No person shall promote, finance, enter into or participate in any foreign exchange transactions where the foreign exchange involved is paid, retained, delivered or transferred abroad while the corresponding pesos are paid for or received in the Philippines, except when specifically authorized by the central bank or otherwise allowed under central bank regulations. Pedro Perez, April 18, 2018. Inserting a finger in a 12-year-old girl's vagina and mashing her breasts are not only acts of lasciviousness but also amount to child abuse punished under Republic Act No. 7610. To the mind of the court, the allegations are sufficient to classify the victim as one exploited in prostitution or subject to other sexual abuse. This is anchored on the very definition of the phrase in Sec. 5 of RA 7610, which encompasses children who indulge in sexual intercourse or lascivious conduct, A, for money, profit, or any other consideration, or B, under the coercion or influence of any adult syndicate or group. Correlatively, Sec. S.A. of RA 7610 punishes acts pertaining to or connected with child prostitution wherein the child is abused primarily for profit. On the other hand, paragraph B punishes sexual intercourse or lascivious conduct committed on a child subjected to other sexual abuse. It covers not only a situation where a child is abused for profit but also one in which a child, through coercion or intimidation or influence, engages in sexual intercourse or lascivious conduct. Hence, the law punishes not only child prostitution but also other forms of sexual abuse against children. By analogy with the ruling in Recalde, children who are likewise coerced in lascivious conduct are deemed to be children exploited in prostitution and other sexual abuse. When petitioner inserted his finger into the vagina of AAA, a minor, with the use of threat and coercion, he is already liable for sexual abuse. Intramuros Administration, March 7, 2018. The sole issue in ejectment proceedings is determining which of the parties has the better right to physical possession of a piece of property. The defendant's claims and allegations in its answer or motion to dismiss do not oust a trial court's jurisdiction to resolve this issue. The contracts of lease expired. Respondent does not concede this, but there is no proof that there has been any contract mutually agreed upon by the parties for any extensions of the leases. Respondent can only argue that petitioner's continuing tolerance of respondent's possession and acceptance of respondent's rental payments impliedly renewed the contracts of lease. But petitioner's tolerance of respondent's occupation and use of the lease premises after the end of the lease contracts does not give the latter a permanent and indefeasible right of possession in its favor. When a demand to vacate has been made, as what petitioner had done, respondent's possession became illegal and it should have left the lease premises. This court agrees with the defendant. The various contracts of lease between the parties notwithstanding, the existence of the other agreements involved herein cannot escape the scrutiny of this court. Although couched in such words as contracts of lease, the relationship between the parties has evolved into another kind, that of a concession agreement whereby defendant Offshore Construction undertook to develop several areas of the Intramuros District. Defendant Offshore Construction actually commenced the development of the subject premises and incurred expense for the said development, effectively making the relationship more than an ordinary lessor-lessee but one governed by concession whereby both parties undertook other obligations in addition to their basic obligations under the contracts of lease. Consensus facit legum, the parties make their own law by their agreement. It behooves this court to respect the parties' contracts, including the memoranda of agreement that ensued after it. Respondent claims that the parties' agreement was for it to operate the lease premises to recover its investments and to make profits. However, a review of the contracts of lease show that they are lease contracts, as defined in Article 1643 of the Civil Code. Article 1643. In the lease of things, one of the parties binds himself to give to another the enjoyment or use of a thing for a price certain, and for a period which may be definite or indefinite. However, no lease for more than 99 years shall be valid. The subsequent contracts, namely, the July 26, 1999 Compromise Agreement and the July 27, 2004 Memorandum of Agreement, also do not point to any creation of a concession in favor of respondent. The compromise agreement affirms the validity of the lease contracts, while the memorandum of agreement was for the payment of respondents' arrears until July 2004. However, this court cannot award unpaid rentals to petitioner pursuant to the ejectment proceeding, since the issue of rentals in civil case No. 081191138 is currently pending with Branch 37. Regional Trial Court Manila, by virtue of petitioner's counterclaim. As the parties dispute the amounts to be offset under the July 27, 2004 Memorandum of Agreement and respondents' actual back and current rentals due, the resolution of that case is better left to the Regional Trial Court for trial on the merits. Civil Code, Art. 1670 states, Article 1670, if at the end of the contract the lessee should continue enjoying the thing leased for 15 days with the acquiescence of the lessor, and unless a notice to the contrary by either party has previously been given, it is understood that there is an implied new lease, not for the period of the original contract, but for the time established in Articles 1682 and 1687. The other terms of the original contract shall be revived. Civil Code, Art. 1687 states, Article 1687, if the period for the lease has not been fixed, it is understood to be from year to year, if the rent agreed upon is annual, from month to month, if it is monthly, from week to week, if the rent is weekly, and from day to day, if the rent is to be paid daily. However, even though a monthly rent is paid, and no period for the lease has been set, the courts may fix a longer term for the lease after the lessee has occupied the premises for over 1 year. If the rent is weekly, the courts may likewise determine a longer period after the lessee has been in possession for over 6 months. In case of daily rent, the courts may also fix a longer period after the lessee has stayed in the place for over 1 month. Civil Code, Art. 22, which states, Article 22. Every person who through an active performance by another, or any other means, acquires or comes into possession of something at the expense of the latter without just or illegal ground, shall return the same to him.